So I know that in probate, there's a different legal status than tenant for somebody who comes into the property, maybe with permission of the decedent, maybe their boyfriend, girlfriend, whatever. They're not a tenant, they're not entitled to the same protections, but they still have certain legal rights. Can you talk a little bit about evicting? And they might be an heir, might be a son of the decedent as well. Can you talk a little bit about the difference of that kind of eviction than, say, a tenant who's paying rent and then they want to get moved out for some reason?
Yeah, so typically what that's going to be in the situations that we have seen, especially like in a caregiver situation, a girlfriend care, situation, when the decedent dies, is that person's what we call an at-will tenant. Basically, there is no rental agreement. There's no agreement for a specific amount of time or about a money. You're basically a guest at the invitation of whomever was there before. And the way that you terminate those is 30 days notice of the death of the person. Because we get it even where it's a rental unit, the mother is on the lease, somebody's staying there, so it's the death of a tenant, and then your termination of the at-will tenancy. And we treat it similarly if it's the owner of the property that is needing to do that. And we've been very successful in those. Typically, we don't even have to go to trial in those. We file a motion with the court just showing what the facts are. They can never prove that they've paid rent. They never can prove that they have some kind of agreement to have a more I don't want to say legitimate, a more traditional landlord-tenant relationship, but sometimes you have to be creative. And, when somebody calls on that, I ask those questions. Are you sure you never took rent, or the decedent never took rent? Because then you have to consider, did they make like mortgage payments or anything like that? But yeah, we call it in the legal world, it's called an at-will tenancy, and they're entitled to 30 days notice, and then you still have to go through the eviction process if they don't leave.
And then there's a different status if that at-will tenant is also an heir. Maybe they're a son, a grandson.
No, because typically in that situation, the ones that I've seen is that asset is the only asset. That asset has to be sold for the distribution. The trustee has the right to dispose of that asset. They're still an at-will tenant. Unfortunately, sometimes I've even had to do it where it's a special needs trust and the person that we're terminating is a special needs. But unfortunately, he's, high on crack and burning up the house in the microwave, so there are certain situations, but it's treated the same way.
And so typically, even with the COVID restrictions that are in place currently or trailing on still, do you practice in Los Angeles? Are you able to get those kind of at-will out within 30 days?
Mm-hmm.
Yeah.
Yes.
And then in the case of an heir, do the legal fees come out of that heir's distribution?
I have no idea how they work that out.
Okay.
I'm paid up front. I'm paid hourly. How they arrange for that, I don't know.
Got it.